Good morning, everybody. I have 9 o'clock on my phone. Madam Court Reporter, are we ready to begin? And we are. Good morning, everyone. We are here for day 2 for case number 230071UT in the matter of the tariffs, agreements, and forms proposed by qualifying utilities for the community solar program. This will be day 2 for our witnesses. Before we begin, do we have any changes or casualties to today's proposed witness list? Any changes that need to be made? Case hearing none. Before we start off, I just wanted to clarify what we were discussing before we ended yesterday and my interpretation of that. In the first pre-hearing order, paragraph W indicates the following: redirect examination shall be limited to a maximum of 10 minutes per witness, except as approved by the hearing examiner. Any recross examination allowed by the hearing examiner in his discretion shall be limited to a maximum of 5 minutes per witness. The scope of redirect examination is matters arising from cross-examination and questioning by a commissioner or hearing examiner. The scope of recross examination is matters arising from redirect examination and questioning by the commissioner or hearing examiner. So I think we have a little bit of a eats, shoots, and leaves, or did you eat, Grandma? Question in regarding that, if you're familiar with those books. Let me just admit Mr. Yar here. This is the way I interpret that, which is on par with what I did yesterday. The scope of redirect examination is matters arising from A, cross-examination, and B, questioning by a commissioner or hearing examiner. So that technically could be an or. I'll make sure to delineate that out in my future orders. But the scope of recross exam then is matters arising from either A, redirect examination, or B, questioning by the hearing examiner. It's not just limited to any questions by myself or a commissioner. So that's the way I interpret that. To the point that I made yesterday, each hearing examiner interprets that in their own way, so you can ask them their own interpretation. That is the way I am going to, proceed with my proceedings. And like I said, I'll delineate that further. So the other point is the scope of recross examination is strictly at the discretion of the hearing examiner. Today, as you are all aware, probably, at looking at the schedule, we have a very tight schedule today. So I am not going to allow recross examination today. We have, right now we have 8.5 hours to fit into an 8-hour time slot. So for purposes of today, my discretion is there will be no recross today. So I just wanted to be upfront about that and just kind of further explain what we were talking about yesterday. Are there any other issues that need to be addressed before we begin today? Hearing none, P&M, go ahead and call your witness.
P&M calls Thomas Dwayne, and there he is. He could be sworn in.
Yes.
Mr. Dwayne, would you raise your right hand for me, sir? Do you solemnly swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Mr. Dwayne. Please state your name and your job title.
My name is Thomas Dwayne, and I'm the manager of P&M's Transmission Planning Department.
Do you have before you what's been labeled P&M Exhibit 9?
Yes, I do.
What is that?
That is my rebuttal testimony filed in this case.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Are there any additions or corrections to it today?
No, I do not have any.
If I asked you the same questions today, would the answers be the same?
Yes, they would.
Mr. Hearing Examiner, at this time, I move to admit PNM Exhibit 9 into the record as evidence.
Request is for P and M Exhibit 9 to be admitted onto the record. Any objection? Hearing none, it is admitted.
Thank you. I tender the witness for cross-examination.
And I believe the only party that requested cross-examination for Mr. Dwayne is NMPEC. So Jane?
Yes, thank you, Mr. Hearing Examiner Mueller. And good morning, Mr. Dwayne.
Good morning.
My name is Jane Yee, and I represent the New Mexico People's Energy Co-op, and it's nice to meet you. I just have really one question. I understand from your testimony that you work directly in the employment of PNM, right?
That's correct.
And in other words, you're not a contractor or consulting. Well, you're not a contractor, correct?
Correct.
And you're not a consultant on transmission, but you work for PNM, right?
That's correct.
All right, so I know that the purpose of your testimony was to respond to certain intervener testimonies. And I want to ask you, though, that you, in the process of responding to intervener witnesses, Farrell and Barnes, you did talk quite a bit about the process of interconnecting with community solar facilities. Is that generally correct?
I would have been talking only to the extent that it affected the transmission system.
Okay, as it relates to the interconnection process, right? As, for example, you discussed on page 2 of your testimony, correct?
Let me turn to that. And where on page 2 specifically are you looking?
Well, for example, in the answer beginning on line 13, but you're discussing the interconnection agreement around lines 20 and so on.
Yes, it's my understanding that an interconnection agreement will ultimately be signed with projects that move forward. My discussion was around uncertainty surrounding transmission cost impacts and potential avoided transmission costs.
So, Mr. Dwayne, have any interconnection agreements been signed between PNM and community solar facilities at all?
I am not aware of any myself. I wouldn't necessarily be in the process. My role has largely been input on the technical studies that are being performed in another department.
Oh,
But I do.
I'm sorry, go ahead, please.
I am not aware that interconnection agreements have been signed at this time.
Oh, so you're talking about the engineering department that negotiates those interconnection agreements when you're talking about another part of PNM in your answer just now, right?
That's correct.
What's the name of that department? I know.
It would be the distribution planning department that would perform the technical studies and would provide the technical input to the interconnection agreements.
All right, so but you are based on your testimony, it sounds like you're the main source of information about any transmission issues that would affect those interconnection agreements, correct, Mr. Dwayne?
I would say that's correct, yes.
So that input would be important before finalizing any interconnection agreements, correct?
Correct.
So what do you anticipate will be the timeline for signing the first interconnection agreement based on your involvement in the process?
I do not have an estimate of that timeline.
And why not?
I have provided my input. I believe that there are still numerous studies being performed on some of the projects. I'm not directly involved in that work. It's largely affecting the distribution system. And I neither review nor comment on the input at the distribution level.
Oh, so you're saying that your work for P&M does not involve the distribution, right? System.
That's correct.
Are you an engineer?
Yes.
So other engineers are implementing P&M's. Other engineers are implementing P&M's involvement in the interconnection as far as distribution goes, right?
That's correct.
And they have not consulted you about transmission. Is that right? Except for your initial input. Is that right?
They have requested that we provide input on the transmission impacts of the facilities that were selected or proposed for the P&M territory. So that information has been provided for inclusion ultimately in the system impact studies.
All right. So just generally taking a step back a moment, generally speaking, the generation of electricity entails generating electricity from a generating facility like San Juan Generating Station, which is now closed, but using that as an example, right? Right, that's the first point of transmission, the generation station, right?
Yes, typically.
And then the electricity travels on transmission lines, correct?
Yes, certainly in the case of San Juan.
Onto P&M's network, right?
Yes.
And then from the transmission system, then it goes through transformers onto the distribution system, right? Or
yes.
I'm sorry to make that compound, but sometimes they're called substations, correct?
Correct.
Yes, I tremble talking with an engineer about these things, but it's still very basic. And so it's an integrated system, right?
Yes.
So what is your knowledge of why have no interconnection agreements been signed yet? And your testimony, let me direct that your answer to what you're talking about in your testimony, which is that it has, and your written testimony and your oral testimony right now, that the timeline includes, has to allow time to accommodate certain upgrades. So what is your information based on your testimony as to that timeline for signing the first interconnection agreement?
I am not in a position to know what that is, what the schedule is for these. I don't know what the community solar timelines have been laid out as. I think the statement you referred to was commenting on the ability to get any needed improvements in place. And that schedule gets identified in the system impact studies.
So the allocation of capacity already occurred, right, in May of 2023. Is that right?
I believe there's a proposed allocation of capacity. Yes.
But the Public Regulation Commission awarded that capacity in May of 2023, correct?
I'm not certain of the date myself, but there is a total capacity awarded signed to P&M.
Yes, and that capacity was assigned in 2023, correct?
Objection, Mr. Hearing Examiner, I'm sorry. The witness has repeated several times that he's not aware of the precise date. If Ms. Yee wants to verify the date with this witness, perhaps she should show him some form of demonstrative exhibit.
It's not, oh, could I respond, Mr. Mueller?
Yeah, I believe the first question she had asked, was it May 2023? He responded he wasn't aware of the date. Are we just going for the year and we're
Yes,
eliminating
sir.
the month? Is that what we're, all right?
Thank
I'm going to allow her to ask if he recalls the year, but if he does not recall, then let's move along.
Thank you, Mr. Hearing Examiner. You can answer the question.
I do not specifically recall the year. I am saying I am aware that P&M has provided an allocation that has been decided.
Okay. So, Mr. Dwayne, is it fair to say that the delays in signing the interconnection agreements do not have to do with the transmission issues?
I would say that's correct.
No other questions. Thank you.
Okay, thank you. I believe my co-hearing examiner, hearing examiner Perez Valero, had a couple of short questions. So, Tatiana?
Good morning, everybody. Thank you, Mr. Hearing Examiner. My question is to Mr. Duane's in reference to page 4 of his rebuttal, line 13. You say, without accessing the transmission system, the electricity created by these community solar facilities could not connect to the load centers, like, for example, Albuquerque. Did you find it?
Yes.
So you are saying basically that transmission lines are indispensable for community solar facilities, correct? Especially
yeah.
far away. So
Yes.
thank you. If there were no transmission lines, what would be the alternative for that extra power? Where do you know if there is any alternative to transmission lines?
There are, I'm not sure I fully understood the question, but without the transmission lines, there are certainly areas where the community solar is backfeeding into transmission. I believe there were numerous substations identified that would backfeed, and that power has to go somewhere on the transmission system.
So the substations are also located nearby the load centers like Albuquerque?
Many of the facilities that were proposed for P and M are pretty remote to the key load centers. In some cases, those areas at times may have net generation that has to be delivered to other parts of the system.
Mhm. Are there like storage systems? Would that be like an alternative to transmitting that power to the load centers?
Storage could certainly play a role in making the effective use of transmission better and potentially reduce the transfers of generation from one area to another.
Mhm. And storage is similar to batteries, correct?
Correct.
Mhm.
Batteries are a form of storage.
Okay, so my question to you, so in the alternative of connecting that power from the solar facilities to the load centers, a substation or a battery would be an alternative means to handle that power, yes or no?
I would say yes.
And do you know by chance approximately, this is not in the testimony, but I'm interested, what's the price of an average battery for up to 5 megawatt solar facility? Do you happen to know?
I do not.
Mhm. Okay. So basically, we can conclude that an alternative to connecting in the transmission lines, that power that comes from the facilities, is a storage or a substation or a battery, correct?
I'm not sure that without seeing the specifics of how storage is used, that I could fully answer that. I would think it would help reduce potential transfers from one area to another. But it really depends a lot upon the total amount of capacity installed in an area as well.
Okay. If the total amount is up to 5 megawatts, what do you think would be the outcome there for a
If you're,
battery?
yeah, so the 5 megawatts to me is the amount that might be connected from one single project. And if you're thinking of co-locating batteries with that project, it would potentially mitigate, at least for a portion of the time, the need to backfeed into the system. But that does require that the batteries be fairly co-located with the facility.
Mhm. That's all I have for questions. Thank you very much for answering.
Thank you. And I see Commissioner Ellison has joined us and has his video on. Commissioner Ellison, do you have any questions for this witness?
No, thank you. I do not.
Right, thank you. Mr. Verheul, any redirect?
I do have some redirect, Mr. Hearing Examiner. Thank you.
Okay.
Mr. Duane, these are with respect to the questioning from co-hearing examiner Perez Valero. And Ms. Co-hearing examiner, I apologize if I'm saying your name incorrect. Mr. Duane, is it your understanding, I just want to make sure this is crystal clear in the record, the transmission system would only be implicated in the community solar, or with respect to the energy coming from the community solar facilities, if it backfeeds from its local distribution system onto the transmission system? Is that an accurate, rough characterization?
I think that backfeeding creates the most obvious use of the transmission system. So yes, that is certainly the scenario that stands out the most. There are situations where the transfer of generation requires, is somewhat dependent upon the counterflow of load. And if that load decreases in an area, you can get into transmission constraint issues to move the generation out.
Okay. I also want to clarify, there was a question about your answer on page 4, starting at line 13, beginning with without accessing the transmission system, the electricity created by these community solar facilities could not connect to the load centers like Albuquerque, and it goes on. Again, I want to be clear, that's only the case where a community solar facility is located or is interconnected to a distribution system and there isn't sufficient load on that particular distribution system. That's where the transmission gets implicated, right?
Correct.
All right. One more question. You got asked about storage, battery storage in particular. And you responded at one point that the battery storage would ideally be co-located with these community solar facilities in order to, well, to be effective. Is that right?
I believe that scenario works. It's not necessarily the only scenario.
Okay. Are you aware of any community solar facilities that have included or that have proposed co-locating battery storage along with their community solar facility?
No, I'm not aware of any batteries being part of the community solar program.
Okay, no further questions. Thank you.
Okay. That concludes this witness. Witness may be excused.
Right, thank you.
PNM, call your next witness.
PNM calls Ms. Lisa Contreras, but it's going to take us a minute for the witnesses to swap out of the witness room. And there she is. If she could be sworn in, we can begin.
Ms. Contreras, would you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good morning, Ms. Contreras. Please state your name and job title.
Lisa Contreras, and I am the Customer Systems Performance Manager for PNM.
And do you have before you what has been labeled PNM Exhibit 3?
I do.
What is that?
That is my direct testimony.
Was this prepared by you or under your supervision?
It was.
Is it a true and accurate account to the best of your knowledge?
Yes.
Are there any additions or corrections to it?
No, there are not.
If I asked you the same questions today, would the answers be the same?
Yes, they would.
Mr. Hearing Examiner, at this time, I move to admit PNM Exhibit 3 into the record as evidence.
Request is to admit PNM Exhibit 3 onto the record. Any objections? Hearing none, it is admitted.
Ms. Contreras, do you have before you what has been labeled PNM Exhibit 4?
I do.
What is that?
That is my rebuttal testimony filed.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Are there any additions or corrections to it?
No, there are not.
If I asked you the same questions today, would the answers be the same?
They would.
Mr. Hearing Examiner, at this time, I would move to admit PNM Exhibit 4 into the record as evidence.
Request is for P and M Exhibit 4 to be admitted onto the record. Any objections? Hearing none, it is admitted.
I tender the witness for cross-examination.
Okay, and I have 4 parties that requested cross-examination time. Let's begin with REIA for 10 minutes.
I believe you're on mute.
All right, how's that? Can you
Much
hear me?
better. Yes.
Good morning, Ms. Contreras. How are
Good
you?
morning. I'm good, thank you. How are you?
Good, thank you very much. If you don't mind, could you please pull up your direct testimony and turn to page 9? Let's go with page 8 and let me know when you're there.
I'm there.
Thank you. I want to talk about the conditions that may prevent a customer who is a community solar subscriber from receiving community solar bill credits, okay?
Sure.
You've indicated that if a customer is delinquent 60 days or more, or a low-income customer is delinquent 90 days or more on their bill, P&M would withhold the bill credit until the customer caught up all of their arrearages, correct? And at that time, when the customer was in arrears, P&M would not apply any bill credits until they caught up. And so I want to just start with asking, is there any de minimis exception? You know, if the customer is 50 cents short on each of those billing cycles, will that trigger the bill credit to be withheld?
So just if I may clarify, and I addressed further clarification in my rebuttal testimony that subscribers who have arrears either 60 or 90 days for non-low income and low income, what we have proposed is that for those arrearages amounts, they either pay them in full or they enter into a payment arrangement and comply with that arrangement for the bill credit to be applied. So we're not requiring them to pay the full arrearage and to become completely current on their bill, but we've established those thresholds for them. Now, to your question of whether 50 cents over, the customer would merely need to pay that 50 cents to be eligible for the bill credit to be applied.
So your answer is yes.
Can you repeat your question just so I make sure I'm...
So you could be in arrearage for 3 months and that 3-month arrearage is 50 cents. So yes, that would still trigger the withholding of the bill credit, correct?
Correct.
You don't. Okay. You later on explain how once the customer has caught up their arrearages, P&M would apply the bill credit. What happens if they don't catch up the arrearages? You don't really explain what happens in that instance.
So once they enter into a payment arrangement for that
Can I stop you?
amount,
Let's assume they don't do that. Okay, I'm saying they just stay in arrears. That's my premise.
sure. No, we would not apply the credit.
And you also say that you wouldn't apply the credits retroactively once they catch up. Can you explain what you mean by that, how that would work?
Sure. So when the credit is not applied, it is sent back to the subscriber organization indicating why it was not applied due to the arrearage. The subscriber organization, at the point that the customer becomes current, could resubmit the
Let me just redirect you. My premise is they don't become current and they don't have a payment plan. That's the question I'm trying to ask. Sorry for interrupting you, but
no, that's fine. So I apologize. I thought your question was, do they ever get the subscription that was not applied? Is
okay,
that your
yeah.
question?
Well, my question is that they don't ever become fully current, that they're continuously delinquent, not just 90 days, but in 120 days, they're still $5 behind. 6 months later, and I'm going to again say that PNM is not cutting them off. Let's say there's a moratorium, it's winter. So what happens to this customer that stays continuously behind? How does PNM, what is PNM going to do with those bill credits?
So for the winter moratorium, the requirement for that is for customers to pay down all their delinquency in order to be eligible, as well as qualifying as low income.
Let's say that customer doesn't pay, they're delinquent for 2 years, and then they get cut off. So I'm just asking you, since you're withholding bill credits and you're assuming at some point the customer will pay up, but what about customers that don't? So what happens to all that bill credit if the customer doesn't ever?
Sure, I apologize. Didn't mean to cut you off.
Well, that's my question. I don't want to assume they get caught up.
So we don't hold that credit for them. We send it back to the subscriber organization.
And then what happens?
The subscriber organization then at that time between them and the subscribing customer, at the point that the subscribing customer becomes current, the subscriber organization can rescind their subscriptions to be applied.
To that customer who's still delinquent?
Well, we're not holding the bill. We're not tracking or accumulating the credit that the subscriber organization sends. It goes back to the subscriber organization. And then the subscribing customer and the subscriber organization would need to work that per their agreement.
So I don't think you've answered my question. Let's say, again, I'm saying that that customer is still delinquent, so it can't be applied to that customer's account. Are you saying that the subscriber organization could apply that again to other customers in the future? Or, trying to figure out what happens to this credit that doesn't get applied to the low-income customer's bill.
It gets sent back to the subscriber organization. We do not apply it.
And then what? What happens after it gets sent back? Where does it go?
It's up to the subscriber organization to determine how they want to handle that with that subscribing customer and with the subscription itself.
And what are the options?
That I'm not aware of because we're not privy to the agreement between that's been entered into between the subscribing customer and the subscriber organization.
Okay, but let's assume again that that customer cannot have it applied because you keep saying that the organization would have to work that out with that subscribing customer. Okay, they haven't been able to. Does the bill credit just go away, or does it or may the subscriber organization then take that unused bill credit and allocate that to other subscribers? That's all I'm asking. Do you know that? I mean, if you don't know, just say so.
I don't know what the subscribing organization would do with that. I believe that would be on them to determine how that's allocated or held.
But from PNM's standpoint, you're not suggesting there's any limitation on how the subscriber organization can reallocate that?
From PNM's perspective, no.
Okay.
I don't understand. I don't believe that it's for us to determine how that subscriber organization manages or handles the returned subscription.
Okay, I just have a couple more questions for you. have you thought about the implications for a low-income customer? Again, we're going to talk about the customer who is not able to make their monthly bill, but they're trying. They're just a little bit short each month. You know, the customer's 50 cents in arrears. Maybe it's going to be $5, but they're paying what they can. So let's assume after 90 days, P&M's got a $300 bill credit there, but the arrearage is $200. Do you see how that could hurt a low-income customer when if P&M applied that bill credit, they wouldn't be in arrears and we wouldn't have a problem. And then going forward, they wouldn't be in arrears and this problem would entirely go away. Do you see how this aggravates the problem of a customer that is in arrears trying to dig out of that hole?
So P&M's approach with the proposal we put forth in handling arrears is one, to help our customers manage their arrears and also to allow them to participate and reap the benefit of the bill credit. So for the amount that they would be over that threshold, we would ask them if they couldn't pay it in full, obviously, just to enter into a payment arrangement for that amount that would be above the threshold. If it's $5, we'd ask them if they could pay that, or we'd work with them so that they could reap the benefit of receiving the bill credit. We're not asking them to pay the full amount. So they are still carrying, obviously, some level of arrear on their account. We're just asking for that amount that's above so that they enter into that payment plan, they comply with it so that they can receive the bill credit on their to their account that reduces their current amounts due.
So your assumption is that they have the money to enter into a payment plan and they don't really need that bill credit to pay their bill. They've got extra money over here. They pay the bill, then they get the bill credit. That's the assumption, right?
I'm not assuming that any of our customers have an extra amount. What I'm saying is that we would work with them on a payment plan for something that a payment that they could make to be eligible.
Okay. Thank you for your answers. And I do believe I ran over a few minutes. Hearing examiner, thank you for your indulgence here. And my cross-examination is finished.
Thank you.
Thank you. I do have one follow-up question that I just want to make sure I'm clear on in regards to that. You said the credit gets delivered back to the subscriber organization. Is there an expiration date, so to speak, on that credit? How long can the subscriber organization keep that credit in their pocket? Or let's say a year later, they say, hey, remember this guy had this credit, we're now applying it elsewhere. Or are there any limitations on how long the subscriber organization can utilize that credit?
From my understanding, and I'm not aware of limitations on how the subscriber organization manages those subscriptions. So I'm not aware that there's any limitations.
Okay, so if they turn in one a year later, P&M's not going to go, that's a year old. It's to your knowledge.
To my knowledge, no. And I don't believe that we would be tracking from application to the subscriber's account a timestamp with regard to their subscription.
Okay, thank you.
Mm-hmm.
Next, we have NEE for requested 45 minutes of time. So.
Thank you so much. And I apologize, I had a problem with my volume and connecting this morning. So Ms. Contreras, I would like to ask you about some of the same questions that Ms. Zor asked you about. I want to try to understand this a little bit better. So why wouldn't P&M apply the community solar bill credit to delinquent accounts. You're getting the energy, but you're not paying for that to the subscriber. Explain that to me.
So if I may, I don't believe that we're getting the energy. We're getting a subscription amount to apply to that bill for that subscriber, customer.
But you are getting the energy from the community solar facility, right? So you're getting that energy. Actually, you have to take that energy. And so it's worth something, right? And yet you're not applying, you're not giving back to that subscriber the amount of money they are due for their subscription. How is that fair?
So our approach, our proposal with the arrears, subscribing customers that are in arrears, is one, as I mentioned before, to help customers in arrears manage their arrears, to help them with that by entering into a payment arrangement so that they can be eligible to receive the community solar bill credit. Additionally, on a broader term, we are also, as you would probably understand, the longer an arrearage goes uncollected, the higher risk of it being uncollected goes up. And so then ultimately that can be considered bad debt, which is then written off, right? And so we, PNM would then try to recoup that through a rate case where it would then affect all customers, not just subscribing customers. So we understand the value to a subscribing customer to be able to benefit from the bill credit. And we've just provided some options that they can get that while also managing those arrears.
So basically what you just said was that PNM would be able, in the next rate case, to get recovery on that bad debt, right?
I'm not saying that we would be able, it would be part of our filing probably, and then it's up to the commission as to what PNM is able to recover.
How many PNM customers live at or below the poverty line?
I don't have the exact number for that. I do believe that, 50% at a minimum of our state is low income.
So is that about how many customers PNM has that live at or below the poverty line?
I am not certain of the exact number for us at this time. I don't have that in front of me.
Right, but even if it's not exact, do you have an idea? Is it about 50%? Is it 40%? Even if it's not a perfect number, just about. I understand that I'm asking you to estimate.
Sure. I would say probably 40 to 50%.
Okay, thank you. And currently, how many disconnect notices does PNM actually send out right now on a monthly basis?
I don't have that information in front of me to be able to provide, and I wouldn't want to estimate and mislead. That is something
it's around like the average in the last 10 years, other than COVID. Okay, let's put COVID aside. But other than that, it's about 17,500 a month that PNM sends out. Isn't that right? About.
I'm sure that would be a good estimate.
Okay. And you know that the law requires, the community solar law requires that 30% of each community solar facility include, or 30% of each community solar facility be low income, right? Include low income people.
Yes, I'm aware.
Okay. If PNM is getting the energy from the subscription that a subscriber buys and is afforded, why doesn't PNM, irrespective of the other parts of the bill, give the solar credit to that customer, especially when PNM will seek recovery of that quote bad debt unquote in the next rate case, and might be whole plus have that capacity?
So, we have proposed a way to help customers manage those arrears, so that they can reap the benefit of the community solar credit. With that, this program is not aligned with other programs that are approved by the commission for the handling of arrears or delinquencies. As I pointed out in my testimony, both the winter moratorium and the budget bill program requires those customers to participate in those programs to pay all delinquency down to zero. We understand the benefit of the credit, the community solar credit. And so we've proposed a way to allow customers to benefit from it while also managing their arrears to bring those down.
Which is what? Which is give the money to the subscriber organization? I mean, what I don't understand is, doesn't the failure to apply the bill credit push the customer further behind?
Once the customer enters into and complies with the payment arrangement, they can receive the bill credit. That will reduce their current bill. And anything from that credit that's in excess of their current bill gets applied going forward, further reducing the bill.
I'm sorry to interrupt you, but I understand the idea of the payment plan. I get that. But I'm asking, how many people right now are in a payment plan in PNM's out of your 500,000 customers, 530,000?
I don't have that number right in front of me. I would estimate probably surely we've probably got a couple thousand payment arrangements in place.
But when you have a person who is on a payment plan now, or they're not providing anything to PNM, but if they're a community solar subscriber, they are providing something to PNM, which is actual capacity, right?
Objection. Mr. Hearing Examiner, I'm sorry, there's no foundation for that statement.
It's just a question, and you haven't said what your objection is based on.
My objection, I apologize, Mr. Hearing Examiner. Should I speak?
Proceed, Mr. Brihu.
Thank you. My objection is the characterization of the subscriber as providing energy to PNM's system. There's no foundation for that statement.
Okay, I'll note the objection. I'm going to allow Mario to continue with her line of questioning.
Do you understand the question, Ms. Contreras?
Can you repeat it, please?
when you have low income customers now and they don't pay their P&M bill, they're not providing P&M with anything, are they?
No.
Okay, but if you have a subscriber to a community solar facility, P&M is receiving some energy, whatever that subscription is, for the subscription, right?
I don't know that I can necessarily say that P&M is receiving the energy for that subscription. The customer is receiving the their subscribed amount to receive a bill credit towards their current
But
charge.
but the subscription, I mean, the solar facility is putting out energy, right? Maybe not 100%, but some, right? Just like all your solar.
As I understand, the facility would be generating, yes.
Okay, so you're getting something from their subscription, presumably. If the solar works, you're getting something, right?
I don't know that, I'm sorry.
No, please.
I don't know that I am in the position to say what the P&M system is receiving or not receiving from the solar facilities. From where I sit in my current role perspective, the customer is receiving the benefit of the subscription that they have contracted with to be applied to their current charges on their bill.
I think we better move on. Let's go to page 7 of your direct, P&M Exhibit 3. And P&M believes it's best to exchange sensitive information like CSV files closer to the time community solar facilities become operational, correct?
Yes.
What are CSV files?
So the CSV file is the format that we have asked for these data transfer files to be provided back and forth there so that they can be uploaded into our billing system.
Do you know what CSV stands for?
Commas, let me refer here. Comma separated values.
Why is it appropriate to exchange this sensitive information closer to the time the community solar facilities become operational?
Sure. So we have basically made a recommendation so that we can test the file exchange before the bill credits, we actually begin receiving bill credits so that we can make sure the exchange between the subscriber organization and P&M, we can have time to work out any hiccups in that file exchange so that at the time that the facility is operational and we start receiving the bill credits, we've worked through some of those hiccups.
It's also because P&M doesn't want the information to be stale, right?
I'm sorry, I don't understand. What do you mean by stale?
Old. You want it close in time. I think you said 60 days because you want to have current information, right?
Yes, we've asked for 60 days out because at this point we are assuming that subscribers have been enrolled and the testing of the data file transfer, we are able to validate it up against current customer information. Just to make sure that the file transfer is correct and the fields are coded correctly. so that's 60 days forward because this is a brand new process. With regard to, well, I'll leave it at that.
You would agree that from a marketing and accounting perspective, there should be as little time between the date between the customer sign up to be a subscriber and the date the community solar facility becomes operational, correct?
Let me clarify. So what we've proposed to ask for that 60-day is just to test the actual exchange. PNM anticipates receiving, as I've outlined in our process, a pre-validation file every month because, to your point, customer data changes, customers move, new subscriber and customers come on, some subscribers may roll off, and we'll receive that on a monthly basis. So the distinction between the two is we've asked for the 60 days really just to test the programming and the exchange back and forth between PNM and the subscriber organization before bill credits, before the facility is operating and we begin to receive bill credits so that we can make sure that there's no delay in applying those credits.
And is this just in the beginning when the community solar program gets started, or do you anticipate this going being essentially a 60-day lag going forward?
Oh, no. Correct. This is just the initial.
Okay. I do have one other question about that other topic that we were talking about the delinquent accounts. If in the situation where there is a delinquent account, then they get on a payment plan, that do they have to start up as a new customer again or a new subscriber? Do they have to do anything like that, or is it just seamless? Is there another payment that they have to make other than getting on a payment plan to receive the community solar credit?
So they would need to pay, they would need to comply with the payment plan that's put into place and pay that and their current charges, which, you know, if they're on the payment plan, would be reduced by the benefit of the bill credit.
But is there a fee for like restarting on or no?
I'm not quite sure I understand what you mean with regard to a restart. We are going to apply what, as long as the customer is, I guess, eligible for the customer in arrears is eligible for by the criteria, we're going to apply whatever the community, whatever the subscribing organization sends us. Any fee or anything like that, I'm not aware of.
So
And it
just
wouldn't be coming from PNM.
okay, just on a practical level. So let's say they're in arrears $50, and then you come up with a payment plan and say, okay, pay $5 more every month for 10 months. I mean, I'm just making this up. And so right then, do they get is the community solar credit that they would have gotten that they had stopped getting, is that banked? And does that apply going forward or no?
So as I pointed out earlier, if they are not eligible at the time that that credit is applied to their bill, that KWH, that subscription, will be sent back to the subscribing organization. Every month when the subscriber organization sends their bill credit, KWH, their subscription, we will apply that. So if the subscribing organization sends, for example, the prior month that wasn't applied and the current month, we will receive and apply, if that customer has met the criteria, we will apply the full subscribed amount.
Well, what I'm confused about is if you've given the money, let's say it's $10 that they made on their energy subscription, and that's withheld for 1 month. And then the next month, do you send that $10 to the subscribing organization?
So we're not holding any bill credit. We're not holding any dollars. If they are in arrears and not in a payment plan, in this case, we don't even apply that subscription. We send it back to the subscriber organization. So PNM is not accumulating the bill credits. We're not holding any credit amount. It doesn't get applied at all. It goes back to the subscriber organization.
But PNM is receiving the energy from that subscription, or else you wouldn't have said, in my example, it was worth $10 to PNM, right? Then, so, right?
Again, I can't say what our system is or is not receiving as far as the generation from the solar facilities.
Okay, I'd like to move on to page 10 of your direct. At lines 14 through 16, you say PNM has begun making the required modifications already in anticipation of needing to be able to issue bill credits to customers who are community solar subscribers beginning in the third quarter of 2024. Is that right?
That is correct.
Isn't it true that PNM has notified its community solar developers that it wouldn't interconnect them for at least 30 months?
I've heard a high level about that, but I don't have any direct or specific knowledge as far as the details or what that is. I couldn't speak to it.
So if that were true, that's like 2.5 years. Is that 2.5 years from now, or 2.5 years from the third quarter of 2024?
Again, I don't know what that supposed delay refers to or the cause of it. I know from what we're working with for our billing system, and we're on target to do that, is to be able to accept the bill credits and apply them on customer bills in the third quarter of this year.
And then could you go to page 12, please?
Okay.
PNM estimates that it will need 7.5 full-time employees and potentially add 4.5 more in year 2. And is that right?
Are you talking about the customer experience advisors?
Yes.
So we've estimated that we'll need 7.5 in total. What we've estimated is at the time that the program stands up, we would bring on 3. And then in the following years, as the customer, in year 2, we would evaluate if any additional would be needed.
And you say that this would support 6,000 additional calls per month?
Yes. That's the estimate.
Yeah, what is that estimate based on?
It's based on what we anticipate or estimate, right? Because we don't know at this point. We estimated that based on roughly 35,000 customers enrolling in this program when it's fully up, that would potentially result in 6,000 additional calls into our contact center.
How many rooftop solar customers does PNM have?
I'm not sure to give you a grand total.
But it's a lot, right?
Yes,
Many, many thousands, more thousands than 35,000, right?
yeah, I think that's fair.
I mean, I have solar on my roof and I've had it for about a dozen years, and I've never called P&M about that solar in 12 years. And I don't know anybody who has solar who's called P&M about it. So it seems to me like 6,000 calls a month for solar that works. It seems extraordinarily high.
So the contact center takes a number of calls for a number of different topics, reasons, right? Because the community solar bill credit is on the P&M bill, we would anticipate that there would be questions for that. And we do take calls from rooftop customers, questions on their bill with regard to their solar or you know, a number of different things.
I have no further questions. Thank you so much, Ms. Contreras. Have a good day.
Thank you. You also.
Okay, thank you. Let me just check the time. I have the remaining NMPEC has requested 15 minutes. Jane, do you still have questions for this witness?
Mr. Hearing Examiner, my questions have been asked. I'm not necessarily answered, but they have been asked. Thank you.
Thank you. And staff, Mr. Black, do you have any questions for this witness?
Thank you, Hearing Examiner Mueller. Staff, similar to Ms. Yee, staff's questions were asked, and therefore staff thanks the P&M witness for her participation in this important matter.
Okay, thank you. That concludes cross-examination. Mr. Verheul, any redirect?
A little bit, Mr. Hearing Examiner, and I'll be very brief because I think you're waiting to send us on break. Is that correct?
My coffee mug is empty. That is correct.
I'll try not to stand too long between you and your coffee mug, sir. Ms. Contreras, your understanding of the bill credit that P&M provides to customers who are community solar subscribers, is that bill credit tracked in dollars or in kilowatt hours?
We receive the subscription in kilowatt hours and apply the community solar rate to that, which results in a dollar credit on the customer's subscribing customer's bill.
Okay, thank you. And I want to clarify, because there was a lot of effort there to sort of muddle the relationship. I want to ask you about the relationship. I view this as a triangle. There's a three-way relationship between subscriber organizations, P&M, and P&M customers who are also community solar subscribers. Do you understand those three parties and think of it as sort of a triangular relationship?
Sure, that's a good picture.
Right. So I'm going to describe it, and I'm going to ask you if I'm describing it accurately. You've got a community solar facility, which is a solar facility of typically 1 to 5 megawatts. And that facility generates electricity, which it then sends to P&M. Is that right?
Okay.
Yes,
yes.
You agree. Okay. P&M in acquiring that energy, then, as you just described, it converts that kilowatt hour subscription to a bill credit, and it provides bill credits to customers who are community solar subscribers. That's right?
Mr. Hearing Examiner, this is Anastasia Stevens. I object.
Ms. Stevens?
This is the most leading testimony by Mr. Verheul than I can imagine. I don't know how this constitutes redirect.
Okay, I'm Mr. Verheul. I'm also of the opinion that the witness has already stated she's really not familiar with the transmission and generation. If we could just get to the meat of the credit question. I think that'll be most convenient, efficient.
Okay, I apologize. I'll try to frame these questions a little bit differently. Does PNM provide a bill credit to community solar subscribers?
Yes, PNM does, based on the KWH that the customer has subscribed to the subscriber organization for.
And is your understanding that those subscribers pay a subscription amount to the subscriber organizations?
I understand that. We don't know what that is or what that's comprised of, but I understand that they do pay a fee for that.
Okay, thank you. No further questions.
Okay. With that, we are concluded with this witness. Witness is excused. Right now, I have 10:16. So thank you, everybody, for staying on time. Let's take a break until 10:30, and we will resume with the next witness. All right, I have 10:30 on my phone, so let's get everyone back. Allison, are we all set? Getting a thumbs up. All right, let's go back on the record. Our PNM's next witness can be called here in a minute. Before we begin that, because due to the amount of time that has been requested by the parties for cross-exam, I just want to make a quick point for time efficiency. During the course of this hearing, there's been a lot of essentially reading a person's testimony and then asking him if that's correct. Don't do that. That's already established when the witness is introduced, that's their testimony. Just refer to the line that you are referring to if you want to read that line for purposes of putting it on the record. I mean, it's already on the record. So just get to the meat of your questions. We're just killing time when we do that. So I would ask, especially for efficiency of getting through this witness, refer to the line that you're referring to and ask your question, so we can move along. That would be my only recommendation, because I'm going to be very cognizant of time here with this witness. So that being said, PNM, go ahead and introduce your next witness.
Thank you, hearing examiner. PNM calls Michael Settlage. May the witness be sworn.
Where'd you go? Mr. Settlage, would you raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. Good morning, Mr. Settlage.
Morning.
You have in front of you what's been marked as PNM Exhibit 5, which is your direct testimony. Is that right?
Yes.
And was that prepared by you or under your direction?
Yes, it was.
Okay. And does PNM Exhibit 5 reflect the errata PNM filed regarding corrections to your direct testimony?
Yes, it does.
Are there any additional corrections to PNM Exhibit 5?
I have no more corrections.
Is this testimony true and accurate to the best of your knowledge?
Yes.
If I asked you those same questions today, would your answers be the same?
Yes, they would.
Okay. I request that PNM Exhibit 5 be moved into evidence.
Okay, request is for PNM Exhibit 5 to be admitted on the record. Any objections? Hearing none, it is admitted.
Thank you. You have in front of you what's been marked as PNM Exhibit 6, which is your prepared rebuttal testimony. Is that right?
I do, yes.
Was that prepared by you or under your direction?
Yes.
Do you have any corrections to that testimony?
I do not.
If I asked you those same questions today, would your answers be the same?
They would.
Is this testimony true and accurate to the best of your knowledge?
Yes, it is.
PNM asked that PNM Exhibit 6 be admitted into the record.
Request is for PNM Exhibit 6 to be admitted onto the record. Any objections? Hearing none, it is admitted.
Thank you. I make Mr. Settlage is available for cross-examination.
Okay, first party for Mr. Settlage is CCSA, requesting 90 minutes.
Thank you, Mr. Hearing Examiner. Shall I proceed?
Please do.
Okay, thank you. Good morning, Mr. Settlage. My name is Jake Schlesinger. I'm representing CCSA in this proceeding. It's nice to meet you.
Nice to meet you.
I would like to discuss first how PNM calculated its community solar bill credit for some of its larger commercial customers that are on demand-based rates. And specifically, I would like to discuss the disagreement between PNM and CCSA on whether or not to exclude monthly minimum demand charges for those customers. You're familiar with that disagreement, yes?
Yes, I am.
Okay, great. And you would agree that how to calculate the bill credit, I'm sorry, let me rephrase. You would agree that in order to calculate the bill credit, one must first calculate the TAR, the total aggregate retail rate, correct?
I agree, yes.
Okay. And the rules in the statute provide a definition of the total aggregate retail rate, and you're familiar with those, right?
That's correct.
Okay. And so, again, I started off by mentioning the minimum demand charge, but that's also referred to as the power factor adjustment, right?
No, the minimum demand charge and the power factor adjustment are two different things.
Okay, can you please explain the difference?
Yes, the minimum demand charge is defined in each rate schedule, and that has a demand charge, sorry. Each rate schedule that has a demand charge defines the minimum demand charge. It's based on a fixed rate times the demand stated in the rate schedule in general. The reactive charge is separate from that. It has to do with the characteristics of the load. Certain loads draw reactive power in addition to the watt hours that they consume. So those are two separate things.
Okay, thank you for the clarification. I think I was confused, but I'm talking about the minimum demand charge. So that's what we'll be referring to.
Okay.
Okay, and so typically a larger commercial customer pays a demand charge based on their maximum kilowatt usage during a specified measurement period in the month, correct?
Correct.
Okay, so just as an example, and I'm using small round numbers here, just to get the concept clear. But if a customer, well, let's say, for example, the demand charge were $1 per kilowatt, and the customer's peak demand measured in the month during the relevant period was 100 kilowatts. Their demand charge would be $100, correct?
Correct. 100 kilowatts times the $1 charge.
Okay. But if there's a month in which, say, they use 0 kilowatts, no demand, they may be subject to paying that minimum demand charge, right?
They would be subject to paying the minimum demand charge, yes.
Okay, and for some classes, that minimum demand charge would be based on an assumed 50 kilowatt minimum usage. And I think for some of the others, it's 500 kilowatts for some of the larger customers. Is that right?
That is correct. Other rate schedules may have a different amount as well. So it's not one or the other. There are other values as well, depending on the rate schedule.
Okay, but 50 kilowatts and 500 kilowatts are pretty common minimums that are contained in your rate schedules.
Correct.
Okay, so under my example above, let's assume the customer was on a rate schedule that had a 50 kilowatt minimum demand charge, and they used 0 kilowatts. They would still be subject to a $50 minimum demand charge, 50 kilowatts times $1 per kilowatt, correct?
That's correct. I think you may have a slight inconsistency in your example. Even if I think the previous example, was it 100 that they used or 10? I don't recall. They would always pay at least 50. So if they had the 10, they would still pay the 50.
Okay, fair enough. Helpful clarification. Thank you. And so your proposal would be to exclude that minimum demand charge in the example I just gave, the $50, because you see that as a minimum monthly charge, correct?
That is defined as a monthly minimum charge in each one of PNM's tariffs. And it has, for the one we're talking about with a demand charge, there are two components. One is the customer charge. The other is this minimum demand charge. Both of those together are the minimum monthly charge. I believe in the order it calls a minimum monthly charge or a monthly minimum charge. The order of the words is switched a little bit, but I think they mean the same thing.
Okay, fair enough. And would you agree that sometimes, I think, we just discussed this, sometimes the customer is going to pay that minimum monthly demand charge, but sometimes they're going to pay for their actual measured demand in the month, right?
Correct. They'll pay for the greater of the two.
Okay, so the minimum monthly demand charge only applies when the customer uses much less than their average demand, right?
Not necessarily their average, but much less than that 50 kW amount.
Okay. And in all other months, they're charged based on their actual demand.
The actual billable demand, yes.
Okay. And you agree, I believe, that the monthly minimum demand charge is designed, at least in part, to recover demand-related costs, right?
Yes.
Okay. And I'm sorry, Mr. Hearing Examiner, can I share my screen real quick?
Give me 1 second to make you co-host. And you should have that ability now.
Thank you, sir. Okay, Mr. Settlage, I have on the screen here the commission's rules and specifically the definition of the TAR. That were some highlights that I added. Do you see that?
I see that.
Okay. And you would agree with me, wouldn't you, that the definition of total aggregate retail rate here on the screen in the top part here, that includes demand charges, doesn't it? The total aggregate rate is the total amount of a qualifying utility's demand, energy, and other charges converted into a kilowatt hour rate, right?
I agree. That's what it says. Yes.
Okay. And I understand that you've proposed to exclude the minimum demand charges based on this later highlight that I have here because it does not include charges described on a qualifying utilities rate schedule as minimum monthly charges. So that's the reason why you propose to exclude it.
That's correct.
Okay. But wouldn't you agree with me here in looking at this definition that the definition explains which minimum demand charges are to be excluded from the total aggregate retail rate?
I'm not sure I'm following about which minimum demand charges. Each P&M rate schedule has a section for monthly minimum charge, I'm sorry. And the ones with demand charges include a clause in there for about the monthly minimum demand charge.
Okay, so let me direct you here to this part that I've highlighted. Total aggregate rate includes blah, 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 but does not include charges described on a qualifying utilities rate schedule as minimum monthly charges, including customer service and availability charges, energy efficiency program riders, or other charges not related to a qualifying utility's power production, transmission, or distribution functions. So the definition provides some specificity about what's included in a minimum monthly demand or minimum monthly charge, correct?
I agree that it uses, like I said, it uses the phrase minimum monthly charges. Each P&M rate schedule has a section called monthly minimum charge that I think that is referring to directly.
Okay. Would you agree with me that demand charges are designed to recover demand-related costs of production, transmission, and distribution?
As a general rule, yes.
Okay. And for the rate classes that we're talking about here, these larger commercial customers on demand-based rates, those customers are also assessed a separate customer charge in addition to the minimum demand charge, right?
That is correct. As I said, each rate schedule has a monthly minimum charge, and one component is the customer charge for every rate schedule.
Okay. And going back to the bill credit calculation, which is actually up right above here in A. The bill credit.
I'm sorry to interrupt you, Mr. Schlesinger. Could you zoom just a notch or two? Like, there you go. My eyes do not read size 6 too well, so that helps. Thank you.
No problem. Thanks for letting me know. It's a little hard for me to know what it looks like on your screen, so appreciate that. Okay, and so the bill credit rule here directs utilities to derive the bill credit from the TAR, as we just discussed, minus commission-approved distribution cost components. Do you agree?
Yes.
Okay. And in determining what the commission-approved distribution cost components are, PNM looks to its most recent class cost of service study, right?
That's correct. Most recent commission approved class cost of service.
Okay. And basically you take everything that's been classified as a distribution cost and you remove that from the bill credit, right?
We remove that from the TAR, yes.
Thank you. Remove that from the TAR. And you also acknowledged just a few minutes ago that some of the minimum demand charges are designed to recover distribution, among other related demand costs, right?
I'm not 100% sure I acknowledged that, but keep going.
Okay, well, do you acknowledge it now?
Could you restate the question?
Yeah,
I apologize.
Are the minimum demand charges designed to recover, at least in part, some distribution-related demand costs?
I believe so. The majority of that would be on the transmission, is where most of those costs are.
Okay, but you're stating that you believe that at least some of them are distribution-related demand charges or costs, rather.
I believe that's correct.
Okay. PNM, sorry, actually, I would like to switch here to CCSA Exhibit 14, which is PNM's response to CCSA's interrogatory 7-5. I believe you're the sponsor, correct?
Yes, I see that.
Okay, and this looks like your response here?
Yes.
Okay. And so when we asked you here in Part B, how the distribution cost component rate calculation was adjusted to reflect the portion of distribution demand costs that are included within the minimum demand charges, you responded that no adjustments were made, correct?
That's my response.
Okay. At this point, I'd like to move for the admission of CCSA Exhibit number 14, please.
Request is for CCSA Exhibit 14 to be moved onto the record. Any objection?
No objection.
It is admitted.
Thank you. Okay. All right, now I would like to talk about the 3% subsidy limit. The statute requires that non-subscribers' aggregate retail rate does not go up by more than 3% as a result of providing community solar bill credits, correct?
Yes.
Okay. And you take the position that aggregate retail rate means something different than total aggregate retail rate, right?
Yes.
Do you know the dictionary definition of the word aggregate?
I could paraphrase. I don't have the dictionary in front of me. It basically means a summation of several components.
Okay. And would you agree with me that the definition of total also refers to the summation of several different components?
Yes, those words have very similar meanings.
Okay. Nonetheless, you have defined aggregate retail rate to include all of the components of the total aggregate retail rate minus fuel and purchase power adjustments. I'm sorry, minus the fuel and purchase power adjustment credit and the renewable energy attributes credit, right? And the source of that definition is simply your own professional judgment, right?
That is correct.
It's also correct, isn't it, that PNM does not use the term aggregate retail rate in any other context in its utility operations, right?
PNM neither uses the TARR or the ARR. These are terms specific to the community solar program.
Okay. I'm going to share my screen again real quick. I'm going to share what's been marked as CCSA Exhibit number 16, which is PNM responses to CCSA's interrogatory 7-8. And you're the sponsor of this response as well, right?
Yes.
And this looks like an accurate representation of your response.
Yes, it does.
Okay, I'd like to move for the admission of CCSA Exhibit 16.
Request is for CCSA Exhibit 16 to be moved onto the record. Any objection?
No objection.
It is admitted.
Thank you. Mr. Settlage, were you listening to the hearing yesterday during my conversation with the EPE witness, Mr. Shishel?
I was listening to some of that. I don't know that I was listening at all times, but I listened to a majority of it probably.
Okay. And so are you aware that he uses a different definition of aggregate retail rate than the one that you've provided?
Yes.
He does not remove fuel and power, purchase power credits or renewable energy attribute credits, right?
I'm not familiar with exactly what he does, but I realize it's different than how PNM is defining that term.
Okay.
Calculating the term.
Okay. And you stated at page 20 of your rebuttal testimony around line 14 that you explain why you interpret aggregate retail rate in the way that you do. You state PNM found it to be the most likely interpretation. Are you at that section of your testimony?
I am now.
Okay. And you explain here that the calculation of the TAR starts with the costs of service revenue requirements for demand, energy, and other charges converted into $1 per kilowatt hour rate, and then adds fuel and purchase power adjustment clauses. You see that?
Yes.
All right. Now, I'm going to share my screen again, and I want to go back to the definition of the TAR. Can you see that?
Yes, I can.
Okay. And can you point me to the section here that supports your position that fuel and purchase power adjustments and renewable energy credits are added to the TAR?
I see that in the words, including fuel and power cost adjustments and value of renewable energy attributes.
Okay, so you would agree with me that what the definition here states is that the total amount of the qualifying utilities demand energy and other charges includes fuel and power cost adjustments and the value of renewable energy attributes. It doesn't say to add them, right?
I read the word including as adding the fuel and purchase power cost adjustments as well as the value of renewable energy to the aggregate retail rate. I'm sorry, the demand and energy rate that's calculated above. So it says convert that to a kilowatt hour rate and add these other two rates to it is what I read there.
Okay, so you read including to mean add.
Yes.
Okay. And then in addition to the fuel and power cost adjustments and the value of renewable energy, it also says that it includes other charges of a qualifying utilities effective rate schedule. You see that?
Yes.
But you didn't propose to remove any other charges besides the two that we just discussed, right?
What other charges are you referring to?
I'm referring to other charges that are referred to here in the rule.
Can you show me those in one of the rate schedules so I know exactly what charges you're talking about?
I don't need to do that. I'm just asking you if you subtracted any other charges besides fuel and renewable energy. Did you subtract any other charges or just the two that...
I'm getting a little crisscrossed on your line of questioning because we're bouncing around the including and subtracting. Can you just ask the witness if there were any other charges based upon that line that he included? Because I'm getting a little fuzzy myself on the line of questioning here.
Understood. And I'm sorry, I think I accidentally said subtracting when I meant to say adding. So thank you for clarifying the record. But no, I'm sorry, I did mean excluding because Mr. Settlage, you excluded fuel and power cost and the value of renewable energy credits from from your calculation of aggregate retail rate, right?
Yes, yes. I think the purpose of the aggregate retail rate is to calculate the cap for subsidies, right? That's the only purpose I'm aware of for aggregate retail rate. And again, thinking about that, a subsidy is something that a customer should be paying or a customer class should be paying, but others are paying for them. And so when I look at this, again, I just want to explain how I arrived, if that's all right, how I arrived at my calculation of the R.
You know what, sir? I think that you explained it in your testimony, and I'm certainly happy to let you have that conversation with your counsel on redirect, but it's not the question I asked, and I'd actually like to just go ahead and move on.
Did I answer your question? I'm not sure I did. I apologize if I did not.
I guess I object. I mean, the witness, Mr. Schlesinger, posed a question. Even though it's not the question, the answer he wanted, I think the witness should be able to answer the question.
Okay, I consider the question withdrawn at this point, so let's move along.
All right, fair enough.
Thank you. Okay, I'd like to turn to table MJS1 here in your rebuttal. Do you see that?
I do.
Okay. In this table, you provide the calculation of the community solar administrative cost rider that PNM proposes using TARR instead of ARR, correct?
Yes, this was in response to a question using TARR. PNM thinks it should be done with the ARR, not the TARR. And also, there was suggestion that we should do this at a total system level rather than just for subscribing classes. I think your witness had that, Mr. Schlesinger. And at this point, I think PNM agrees that it should be done at the system level, not on just the subscribing classes level. So I just want to say that there's this is not PNM's current view of how this subscription cap the subsidy cap should be calculated. We think it should be based, as your witness suggested, on the total system, not just on subscribing classes.
Okay, so are you saying that, okay, well.
But your points are probably still good. We can use this as an exhibit to highlight your questions. I think that won't change.
Okay, so other than the fact, let me back up. Other than using TAR instead of ARR, and other than the fact that PNM believes that all customer classes should be included in this table still represents your proposal on how to calculate the subsidy, right?
Those two changes, they change the numbers obviously substantially, but yes, the principles are the same. If you start at the top with the annual energy sales, the ARR, the annual subscription, calculate non-subscriber sales and calculate the cap. Yes, that is the math we believe is correct. But these numbers here are not what we believe is the proper basis for that calculation.
Okay, fair enough. And so the methodology is correct. And I believe it's consistent with the methodology that you presented in this table in your direct testimony, correct?
Correct. Again, other than the fact this broke it out and summed up the individual classes rather than doing it at a system level.
Understood. Okay. Well, then, as you said, I think it's still useful to highlight and make sure that we're on the same page with regard to the methodology, understanding that the numbers are maybe not correct. Yeah. And you would agree that using the TARR instead of the ARR has the effect of reducing the subsidy cap by about $5.4 million, right?
The numbers would be different. I agree that it has the effect of reducing it. Yes, in this example, the way PNM originally proposed, before we understood what your witness was proposing and decided their method was better doing it at a total level, yes, the reflection is there, as you stated.
Okay. And then, so again, this table only provides residential, small commercial, and large power. And you clarified just now and in discovery that PNM intends to include all rate classes when it does this calculation in the future, correct?
Correct. We also intend to use the definition of the ARR rather than the TARR.
Understood.
For very important reasons, yes.
Okay. But in this example that you provided for these three classes, you calculate on line 5 what the 3% subsidy cap is for each class, right?
Correct.
Okay. And then on line 7, you basically calculate the difference between the bill credits and the subsidy cap to arrive at essentially costs above 3%, right?
Correct. I want to point out, though, this is definitely a sample calculation because those bill credits that are used here are simply the bill credits. There may be other costs, if you will, but there would also be avoided costs that would be netted from that. So this is just a very simplified, some numbers I could pull together to illustrate the math.
Okay. So again, understanding that this is just an illustration, for the residential and small power classes in this table, there would be no bill credit cost above the 3% cap, right?
That's what the math in this table indicates, yes.
Okay, and just taking residential as an example, that's because the 3% cap is 11.9 million, but the bill credits only come to 10.4 million, and so that cap hasn't been exceeded, and therefore there is no costs above 3% in line 7, right?
That's correct, but remember, the way PNM is proposing to do it is not just the bill credits, it'll be net of bill credits, other costs, as well as avoided costs. That's the number that's there is an illustrative number, but that is not the number that will necessarily be when PNM has this filed in a rate case seeking recovery.
Okay, I understand that. You've mentioned that several times, and I'm just looking at this table for methodology and as an example. So understanding that, you would agree with me that line 7 here states that it subtracts line 6, the bill credits, I'm sorry, it subtracts line 5, the 3% cap, from line 6, the bill credits, right?
Correct.
But 10.4 minus 11.9 would result in a negative number, right?
Yes, it would. It's capped at 0.
It's capped at 0, so that's why you don't have a number here.
Correct.
Okay. But if we were to look at the right-hand column here, the right-hand column totals these numbers in lines 3 through 7 from the residential, small power, and large commercial, right? That's what these are, the total of all three of those?
That column is the total of that row to the left, yes.
Okay. And so if we look at line 6 here, for the total of these three classes, I'm sorry, line 5, for the total of these three classes, the 3% subsidy cap is $17.5 million, right?
Yes.
But the bill credits that are paid out to those three classes in aggregate are less than $17.5 million, right?
Yes.
So we haven't hit the cap.
Well, again, this table does not illustrate the way PNM is proposing now. I think you're getting at the reason that in row 7 is not the simple subtraction of the lines above it in the column labeled row total is because of that capping where the subsidy can't be negative. It's not feasible to have a negative subsidy. That doesn't make sense. That's why that is different. But again, this problem goes away with the methodology that PNM is proposing based on your witnesses' suggestions.
Okay. So, so you're saying that you would not, if only the large, okay, let me back up. The 1.2 million that's down here, that represents just the costs above 3% incurred by the large power class, right?
It represents the sum of all of them, just the others are capped at 0. So when you sum across that row, just as we do for the rows above, it's the sum of all of them in the same row.
Okay.
And in this case, the only one that is the only one that's positive is that one under large power.
Okay. So would PNM, if it were to do this calculation with the correct numbers and all the classes, and it ended up with a number here but still had blanks in some of the other classes because there was headroom, would you seek to recover that $1.2 million from subscribers or not?
No, just to simplify this so it's more aligned with the PNM's current proposed way of doing this, you would not even have the residential and small power columns represented here. It would all be done at a system level basis. So the only thing would be, rather than saying row total, it would be system, and the subtraction would be just as you'd expect. Row 5 minus row 6 would be a very small number.
Okay. Okay, so, okay, well, you know what? I think that actually resolves my question. So you're but just to be really clear, in this table, we would have resulted with a positive subsidy amount because only the large power class exceeded the cap. But you're saying that going forward, you will look at all of the classes together, correct?
We will look at it on a total system basis, yes, which includes all the classes. Okay,
so this methodology then of including a $1.2 million Rider 57 subsidy actually wouldn't be your current methodology. You wouldn't have come up with a number here based on the summation of these three columns: residential, small power, and large power.
That's correct. We would use a system total for that. And so there would be no capping of the individual components at 0.
Okay, great. Well, that shortens things a bit. So thank you for explaining that. Let me find my place here since I'm going to be jumping ahead. Okay, on page 32 of your rebuttal testimony, you provide support for Mr. Babe's rebuttal testimony regarding PNM's proposal to track carryover amounts as a means of enforcing subscription size limits, correct?
Yes, yes.
Okay. And you note that in the analysis that you presented, unless the community solar subscription is significantly larger than the customer's consumption, it's difficult to have a carryover amount in 6 months out of a 12-month period. I'm not going to ask you if that's correct because that's annoying. But but we asked you a discovery question about this, and so you know, let me just put that up on the screen real quick. This is what's been marked as CCSA Exhibit number 7, which is your response to our interrogatory request 7-9, correct?
Yes.
And this
Just
is
clarification. I believe that's Exhibit 17.
correct. CCSA Exhibit 17.
Okay.
And this is an accurate representation of your response?
Yes.
Okay. And so you would agree that a winter seasonal user of electricity, for example, a seasonal resident that has electric heating, they may need to bank significantly more credits in the summer months when they have relatively low usage in order to cover 100% of their winter usage, right?
That's one piece. There's two moving pieces here. Solar production varies throughout the year as well as customer consumption. In general, they vary. They're usually not constant, but yes.
Okay. At this point, I would like to move for the admission of CCSA Exhibit 7.
Request is for CCSA Exhibit 17 to be admitted onto the record. Any objection?
No objection.
It is admitted.
Okay, thank you. And then what I'm putting on the screen right now has been marked as CCSA Exhibit 18, and this is your response to interrogatory CCSA 5-16, correct?
Yes.
Okay, and this is your accurate response?
Yes.
Okay, I'd like to move for the admission of CCSA Exhibit 18.
Request is for CCSA Exhibit 18 to be moved onto the record. Any objection?
Objection.
It is admitted.
Okay, thank you. I don't have any substantive questions about this, but I did want to get it in the record, so I have no further questions. Thank you.
Have a good day.
Okay, thank you. Next we have REIA.
Yes, thank you. Can you hear me?
We can.
Yes.
Well, that was a surprise when I'm expecting 2 hours from CCSA. So, but I think I'm ready to go ahead. Before I start, would you mind, Mr. Hearing Examiner, if I add 10 minutes to my 5 minutes I still have? Ms. Nanasi has agreed to cede me 10 minutes of her time, and she's also indicated of the 45 she reserved, she does not intend to use all of that. So I think this will actually expedite things.
That's fine with me. Between the two of you, you can take us up to 12 o'clock or less.
Thank you, sir. Mr. Settlage, could you pull up your rebuttal testimony? You may already have that in front of you.
Yes, I've got that right in front of me.
Okay, I also want to ask you about the minimum demand charge.
Yes.
So I'm looking at page 17.
One
And
moment. One moment.
sure, take your time.
Okay, I'm there.
Okay, thank you. And I'm not going to go over everything you said here because I'm going to assume everyone's read this. I'm just going to go right to my questions here. You give an example of how you would calculate the minimum demand charge on line 7 of page 18, where you say, for rate schedule 4B, the minimum demand is 500 kilowatts per month. Based on the tariff language above, if a customer has 0 actual demand in a month, the customer is still responsible for paying the demand charge based on 500 kilowatts. So I want to ask you a slightly different question about your example. How would a customer who has exactly 500 kilowatts of demand, what would their monthly minimum demand charge be?
They would be one and the same.
And so that customer would never get any bill credit for any of its demand if it used the exact amount of the minimum monthly, the 500 kilowatts minimum demand every month, correct?
I think that's correct. Yes.
In your explanation of the tariff, if you would go up to where you explain the determination of total demand section.
Which page and line? I'm sorry, could you point me to the right place?
Yes, sir. Page 17, line 19.
Thank you. Thank you.
And then you have a little excerpt, which I believe is from rate 4B.
That's correct.
Okay. Of those 4 different possibilities for calculating the total demand, of which PNM says the highest of those choices will be the minimum demand you apply, is that correct? Whichever's the greatest?
Yes, the tariff says it's the greater of these 4 possible conditions.
So when you calculated the amount of revenue that you considered minimum bill charges that you're not including in the credit, did you just look at the 500 on a rate schedule? Again, let's just talk about 4B. Did you just take the number of customers and use the 500 kilowatts, which is the minimum, or did you use A, B, C, and D in determining? Did you just do one of those, or did you do all 4, a combination of those, and coming up with the amount of demand credit that's excluded?
Yes, I looked at all 4 and calculated that the lowest possible demand credit is based on condition C, which is the minimum demand defined on the schedule. Because a customer could have a higher actual usage, they could have had a higher actual usage in previous months, or they could have a higher contracted minimum. But using condition C, the only one I did use in that calculation is the lowest possible calculation for minimum demand. And having a
Okay.
low minimum demand, I'm sorry, I didn't mean to, you mind if I
No,
continue?
go ahead. Yes, go ahead, please.
Thank you. And having the lowest possible minimum demand dollars results in the highest possible bill credit. If I had used the other conditions, it would have resulted in a slightly or maybe significantly smaller, but smaller nonetheless bill credit. So this was a way to be conservative in calculating this minimum monthly bill to comply with both the tariff and the order and have the best possible, highest possible credit for customers, community solar customers.
If a customer fell within a actual metered on peak kilowatt demand, that they wouldn't have a minimum demand charge though, would they?
No, it'd be
They
much
would
higher.
have,
It would be a higher
but-
charge, yes.
okay, but let's assume that customer, it would be higher, but it wouldn't be under a minimum demand, right? It would be an actual demand, correct?
That's correct, but that's not exactly how this is done. Can I give another example to help illustrate?
Yes.
So when we're excluding the customer charge, for instance, there doesn't seem to be any contention that the customer charge should be excluded. What we use there is we look at the number of customers times that fixed customer charge rate to come up with dollars and divide that by the energy. And that's how we're excluding the customer charge. For the minimum demand, we're really doing essentially the same calculation. We're taking that minimum demand amount, as I said, the lowest possible minimum demand amount, multiplying it by the tariff demand rate, getting those dollars and dividing by the class energy to come up with that component. So the calculation is the same.
I'm sorry, go ahead.
The calculation is in principle the same as what's done for the customer charge.
So with the customer charge, all you need to know is how many customers and what else?
And the filed rate customer charge, whatever that
So
might be.
So if that was $20, it'd be, and 100 customers, it's $100 times 20 customers, correct?
Correct.
Okay, so you have pulled this paragraph at the bottom of page 17 from the tariff. And what you've just told me is that this paragraph is the determination of total demand. And that would be a determination for an individual customer under the rate, correct?
Yes, the determination of total demand is used in the calculation of the minimum demand charge, the minimum monthly charge.
But in the tariff itself, the determination of total demand is on a customer per customer basis, correct?
Yes.
And you've indicated that you're not really applying the determination of total demand. You're just applying C, correct?
I'm sorry, I didn't catch that last word, applying.
You're not.
Oh, C. Yes, I understand. Sorry, I missed.
And let me clarify what C is, because I know we've been discussing this, but it won't be clear for the record. C meaning line 23, page 17, C, the minimum demand defined in the schedule. Okay, so I'm going to ask this. I think you just answered it, but I kind of lost my train of thought here. So you're saying it's correct that PNM looked at C in determining the amount of total demand that should apply for the purposes of the community solar calculations, correct?
Yes.
Okay. I'm just going to tell you my thoughts, and you can, agree or disagree. But it sure sounds to me like this determination of total demand is very much unlike a customer charge, and that the customer charge, we just need to know what the bills are and how many customers there are, or what the customer charge is and the number of customers, and we could do the math. But here, it sounds like you've taken a shortcut and you just went directly to C rather than applying that whole paragraph in there, all of which is part of rate 4B, correct?
the reason I did that is to make the credit as high as it could be. I mean, we could calculate the minimum demand using these other conditions, which would result in an even higher value for minimum demand. But I didn't think that was appropriate. It's a lot of effort to do that. And PNM is willing to use this because I think it's a reasonable capture to comply with the act, which says we have to deduct not just the customer charge, but the full monthly minimum charges. The monthly minimum charges include customer and demand. And so we selected the most advantageous calculation of that minimum demand in the use of the credits. So the credits are the highest.
I think the point I'm trying to make here is we would calculate this differently than a customer charge, which is obvious, and that you are not actually doing a simple calculation of what a minimum demand charge is by the number of customers. If you wanted to actually know it, and let's say you decided not to be so generous, wouldn't you have to go through and for each customer, you'd have to see, did they fall under A, B, C, D, and then what's that customer's revenue? And then you'd know how much minimum demand there was in a particular year. But then the next year that would change again because it varies by so many different things, including every month's demand, right?
I don't think I could quite agree with that. You know, the way I've done this, again, if we did it the way you're suggesting, it could only end up with a higher number because the lowest condition is that it could ever be is the demand stated in the tariff. Using any of these other conditions will only make that higher, not lower.
Right. I'm not arguing.
And I don't see that it's different than a customer charge. You know, when PNM files a rate case and comes up with the cost of service, we have what are known as billing determinants, things like the number of customers, the amount of energy those customers use, the amount of demand they have. And so all those things are what goes into the calculation of these rates that are in this rate schedule 4B we're talking about.
And you have to use a number of billing determinants if you were to fully apply all of that paragraph on lines 21 to 24 on the bottom of page 17, right?
We did use the full billing determinants in determining the way I have done that. Yes, that is the full class billing determinants.
Okay. I think what I'm getting at is that paragraph to me sounds like what you said on 19. It's a determination of total demand, not a minimum bill charge. This is how you calculate an individual customer's demand. And the only way this seems to work is if you only use C. Then you could come up with a number that's more analogous to a customer charge where we know it's $20 times 100 customers. And so I guess what I'm questioning here is this a determination of a minimum bill charge in the tariff or a determination of how the demand charge is applied?
I think
do you see that distinction?
I do. I think I understand what you're trying to say there. But again, if you look at that tariff, so maybe we should, well, PNM Exhibit 13 is the copy of Rate Schedule 4B. And we don't necessarily have to pull that up. I can tell you what it says. You can check and make sure I'm accurately reflecting that. But well, it has a section.
Hold on a second. It's attached to your testimony, right? So if you want to talk about it, I don't mind if you want to pull it up. That would make the record a little bit more clear. I think it was attached to your direct testimony.
Hearing examiner, if I can share my screen if you'd like to make, and I have PNM Exhibit 13 up here, if you'd like to make that.
Thank you. That's fine with me. Is that okay, Mr. Sedlich?
Yes, I'm just concerned with the technology. If I try to share it, I'll screw something up, to be quite honest.
Yeah, me too. I'll overshare.
Your council is now co-host, so you should have screen sharing ability.
Thank you.
Okay, so let's just look at it and maybe that would help us to
understand. Think that will help us. So on page 3 of this, keep going down a little bit.